As is one of the most misunderstood terms in California real estate transactions. Here are the key misconceptions and the actual legal implications. Many buyers and sellers mistakenly believe that an as-is clause means that the seller is completely off the hook for any issues with the property. Essentially, that the buyer takes on all risks and the seller has no further responsibility, including for disclosures of defects. This is incorrect. What as-is actually means is that the buyer is agreeing to purchase the property in its present physical condition with no guarantee or promise from the seller to make repairs or improvements. The seller is not obligated to fix anything that is discovered, but the buyer can still ask for repairs or credits after inspections. The seller just isn't required to agree. The most critical legal point is that as-is does not relieve the seller of their legal duty to disclose all known material facts and defects affecting the property's value or desirability. California law is clear. Seller must disclose issues like roof leaks, foundation problems, or any other known defects, even in an as-is sale. Failure to disclose can result in lawsuits for fraud or misrepresentation. As-is does not mean the buyer waives their right to inspect the property or to back out based on what they find during inspections, unless the contract specifically removes those contingencies. The buyer is still entitled to perform due diligence, and if dissatisfied, can often cancel the contract within the contingency period. In everyday language, as-is often used as shorthand for the seller won't do repairs. Legally, however, it simply clarifies that the property is being sold in its current state, but does not alter disclosure obligations or eliminate inspection rights. Some listings emphasize as-is to deter repair requests, but California's standard purchase agreement already includes this language for all resale homes. This can lead buyers to believe some homes are as-is and others are not, which is not accurate. Key takeaways for buyers and sellers. Sellers must always disclose known material defects even as-is sales. Buyers should always conduct thorough inspections and understand they can request repairs and credits, though the seller is not obligated to comply. As-is does not equal no disclosure or no resource for hidden defects that the seller knew about. The term does not remove the buyer's rights to cancel within contingency periods if new issues are discovered. If you're a seller, disclose everything you know. If you're a buyer, inspect thoroughly and understand your negotiation options. As-is about the seller not being required to make repairs, not about hiding problems or removing the buyer's rights. This clarity is essential for both parties to avoid costly misunderstandings and legal disputes. If you have any questions or want to make sure you have true clarity when buying a home in California, reach out. I'm Farnaz. Thank you for watching.